It's a great honor to be invited, but I really would have appreciated being there with you today and discussing all these important topics together in this room where you are. But unfortunately, it's impossible for me, at least today. I would like to thank the Center for Climate Law and Sustainability Studies class, and especially Dr. Hanna Millerova for this very timely and extremely relevant event. And I would also like to thank the previous speakers that I had the privilege to listen to, Mark Limon and Justice Jelic, for their very, very interesting contributions and their excellent insights. I'm really, really looking forward to the discussion. Thank you so much for inviting me. It's a great honor. What I would like to do in my talk, I think, fits quite well with what we just heard from Justice Jelic, and it may be considered to be picking up where she left at the end of her talk. I'll be focusing on the substantive dimensions, climate dimensions of human rights obligations in the way that the standard of care with regard to climate change. And I will present the argument that in order to comply with their human rights obligations, especially under Article 2 and 8 of the European Convention on Human Rights, states must take all adequate and appropriate measures to globally phase out greenhouse gas emissions around 2050, but also have effective measures in place prior to 2050 to get there. But I'll go into much more detail a little bit later in my talk. I have divided my talk into 4 parts. Very briefly, I'll say something about the factual linkages between climate change impacts and human systems. I know that Dr. Millerova already spoke about this earlier today, so I'll try to cut this short. I'll then say something about climate change as a matter of human rights law before I then dive into these substantive obligations, human rights obligations with regard to climate change. As a caveat, I will not address matters of process, especially standing, victim status, exhaustion of national remedies, and other procedural measures, as Justice Jelic just went through all these requirements in her excellent presentation. So let me start first with the factual linkages between climate change impacts and human systems. We all know that projected climate change impacts pose significant challenges to natural and human systems, and that the higher the temperature increase, the higher the risk. That's a very simple equation, but this is what we know, and this is what the IPCC repeatedly has been telling us. The Intergovernmental Panel on Climate Change, in its special report on global warming of 1.5 degrees, already from 2018, projected significantly higher risks at 2-degree warming compared to just 1.5 degree warming. But even at 1.5 degree warming, we're looking at significant impacts on human systems. These include human exposure to increased flooding and drought, water stress, smaller net yields of crops, loss of livestock, reduction in food availability from fisheries or aquaculture, impacts associated with sea level rise, changes in the salinity of groundwater, severe precipitation, damage to infrastructure, and so forth. It's a long, long list, and I won't go through all of it. But in addition to those direct impacts that we all know very clearly, climate change also interacts with and intensifies poverty, conflict, and unrest, resource depletion, food insecurity, loss of livelihoods, infrastructure breakdown, and loss of access to essential services, including electricity, water, sanitation, healthcare, as well as relocation and migration. Now, each one of these impacts, either direct or indirect, is deeply worrisome. But if we look at the sum of projected impacts, the accumulation of those impacts, that is when the real alarming picture emerges. And addressing the causes and finding remedies to these adverse effects to human systems is an unprecedented challenge, both in scope, in scale, and in urgency. And that's something that the IPCC, in its latest first part of its 6th assessment report, highlighted just a couple of months ago. Now, let me second turn to the question of whether this makes climate change an issue of human rights law. Now, the climate change effects have, of course, a major impact on human rights already today, but could have cataclysmic impact in the future unless ambitious action are taken immediately. Among the human rights being potentially violated or threatened are, as we just heard, right to life, right to private life, Articles 2 and 8, under the European Convention on Human Rights, Article 14, right to non-discrimination, but also right to food, water, sanitation, the right to a clean, healthy, and sustainable environment, as we just heard from Marc Limon, and right to an adequate standard of living, housing, property, development, and culture. There's a whole catalog of rights that potentially will be impacted or are already impacted by climate change. Now, the matter of climate change and human rights, as we know, is addressed in different separate treaties, at least internationally. On climate change on the international level, we have the Paris Agreement, adopted under United Nations Framework Convention on Climate Change. And in domestic law, we also have very specific climate regulations. But these treaties and laws do very seldomly, if ever, address the human impact, the human rights impact of climate change. They basically look at the solutions of the problem, the reduction of greenhouse gas emissions called mitigation, or technical solutions to adapt to the adverse effects, adaptation. But human rights impacts are largely outside their scope. For human rights, we have other treaty regimes, and you're all familiar with them, and usually other provisions in national legal systems, such as constitutions or particular human rights acts. Now, the laws and regulations to address climate change and human rights exist in different silos. And this is aptly expressed in the Paris Agreement itself, which in its preamble acknowledges that parties should, when taking action to address climate change, respect, promote, and consider their respective obligations on human rights. And that particular paragraph was now being reiterated by the COP in Glasgow, especially the CMA, under the Paris Agreement. The formulation, their respective human rights, refers to already existing treaty or customary obligations of states under human rights law that parties already have. So in other words, the Paris Agreement kind of throws back the ball into the human rights field and says, states, when taking action, consider your human rights obligations. They are there and you have to be aware of them. But there are certain linkages, of course. States have the obligation to ensure or to protect, respect, and fulfill human rights to everyone within their jurisdiction, and also outside their jurisdiction, as we now learned from the Committee on the Rights of the Child, that there also extraterritorial extension of that obligation. And the foreseeable and potentially catastrophic adverse effects of climate change on the enjoyment of a wide range of human rights everywhere in the world, but also here in Europe, gives rise to extensive positive duties of states to take immediate actions to prevent those harms. International human rights treaties provide for human rights that are being interpreted or can be or should be interpreted in the light of those climate treaties, in the light of the normative environment within which they exist. So in this context, the climate treaties, the Paris Agreement, the United Nations Framework Convention on Climate Change, but also their science-based character, come in when we deal with interpreting human rights treaties, when interpretation of, for example, Article 2, Article 8 of human rights, of the European Convention on Human Rights is taking place. Now, I will now turn to that third issue of the substantive content of human rights obligations with respect to climate change. As I said, they're both procedural, substantive obligations, and I'll focus on the substantive aspects, the climate dimension of human rights obligations. The European Court on Human Rights, as we just heard, as well as the Inter-American Court on Human Rights, have long recognized that parties have positive obligations to secure human rights, and this imposes a duty on national authorities to adopt reasonable and appropriate measures to effectively protect rights, and to provide deterrence against threats, including against risks that may materialize in the long term, but we already see the causation of that risk being starting today, such as climate change. So the central question, therefore, is when can it be said that states comply with these obligations, with these positive obligations? And I dare say that the fairly simplistic or relatively easy answer is, well, basically when they adopt measures that are aimed at, that are effective and just to prevent dangerous climate change. Let me specify this a little bit further. Which climate mitigation measures or which level of ambition would be, could be, should be considered reasonable and appropriate? And in answering this question, I think any court should take into account elements of international law, as I already said, and interpret the obligations consistently with the legal environment in which they exist. And this applies in particular to the Paris Agreement, to which we now have currently 195 member states. In this context, in particular, Articles 2, paragraph 1 and Article 4, paragraph 3 come into the picture and are relevant in that discourse of interpretation. Article 2, paragraph 1 of the Paris Agreement, just a second, sets out, of course, as we all know, the global goal of holding temperature increases to well below 2 degrees centigrade. And pursuing efforts to limit increases to 1.5 degrees. And this sets an international standard. This is the object and purpose of the agreement. This sets an international standard which with significant implications. In order to achieve this long-term temperature goal, parties have collectively committed to global peaking of greenhouse gas emissions as soon as possible, understanding that developing countries might take a little longer, and recognizing and to undertake rapid reductions thereafter with the aim of achieving a balance of emissions and removals in the second half of this century, or global climate neutrality, as it also can be referred to. This goal is informed by best available science, which is assessed by the IPCC, which stated that pathway consistent with holding global temperature increases to this goal would need to see emission reductions by 45% by 2030 and global net zero emissions around 2050 and negative emissions thereafter until the end of the century. And this is exactly what was now recently confirmed by the parties to the Paris Agreement at COP26 in Glasgow. The other article that I mentioned, Article 4, paragraph 3, sets out the legal agreement that each party has to communicate, prepare, and maintain a nationally determined contribution that it intends to achieve with the aim of holding temperature decreases to the global goal included in Article 2. Now, importantly, each party's NDC will reflect each party's highest possible ambition. That is written in Article 4, paragraph 3. And this provision, highest possible ambition, expresses the obligation of conduct that each party will deploy its best efforts in setting its national mitigation target in its NDCs at the highest level and in pursuing domestic measures to effectively achieve it. This paragraph establishes for each party a due diligence obligation to attain its highest possible ambition in a manner that reflects its national circumstances, that is, responsibilities and capabilities. An obligation of due diligence means that states must deploy all reasonable and appropriate means to exercise best possible efforts, or simply just to do their utmost. The due diligence standard expressed in that article of the Paris Agreement as an obligation of conduct requires that each respondent sets its climate change mitigation at the highest level that is not excessively or excessively disproportionate or impossible to achieve. That's the threshold, and it's a very, very high threshold for assessing this, I think. Such a target will have to be set in light of the overall long-term temperature goals of the agreement. It should be comprehensive which means it needs to cover all sectors and greenhouse gases, and it needs to be based on a thorough assessment and application of all mitigation options and potential in all relevant sectors. In other words, parties need to deploy all political, legal, socioeconomic, financial, and institutional capacities and possibilities in defining their target in line with that due diligence obligation. It also requires parties to have domestic measures in place that are necessary, that are meaningful, that are fair, and indeed effective to achieve that target. In other words, this requires deep emission reductions already in this decade to ensure that the achievement of global net zero emissions around mid-centuries remains possible. It also requires, as we know now from the German Federal Constitutional Court, a fair and proportionate allocation or sharing of burdens on an intertemporal scale, so as to avoid that the heavier lifting is postponed. In order to achieve global net zero emissions, those parties that are in a position to do so according to their responsibilities and capabilities will need to reach net zero targets much earlier than 2050 in order to enable everyone, to enable a global net zero achievement around 2050. This means, for example, that the European Union and its member states would need to cut greenhouse gas emissions much earlier and much deeper in order to ensure the global goal remains achievable. A long-term plan to achieve net zero emissions does not mean that European member states can delay ambition and rapid actions. Now, actually, the IPCC warns that every year's delay before initiating emission reductions decreases by approximately 2 years the remaining time available to reach net zero emissions, consistent with 1.5 degrees. States also have to ensure that corporate behavior, financial flows, public and private investments and actions are consistent with a pathway towards low carbon emissions and climate resilient development in accordance with Article 2, Paragraph 1, Litera C of the Paris Agreement, which is another goal which is at the same normative level as the global temperature goal. In their regulatory framework, they need to ensure that their own carbon neutrality does not lead to rising emissions in other parts of the world due to exported emissions or so-called leakage. This occurs, for example, where production processes that happen or consuming of products that happen within the EU are outsourced to other states and lead to increased emissions in third parties. It also occurs through the export of fossil fuels or fossil fuel products, just so for example as plastics, which increase greenhouse gas emissions in third parties when combusted or incinerated there. So in sum, in order to secure the rights, for example, under Article 2 and 8 of the European Convention on Human Rights, each party must approach their climate policies with due diligence. This means that they must have in place a shorter-term goal for 2030 for rapid, deep emission reductions, but also reflecting its highest possible ambition and a very detailed plan of reaching net zero emissions well before 2050. Complying with human rights obligations requires drastically accelerated climate action. We know this very well by now at the level of each state's highest possible ambition. By not adopting targets and reducing emissions at that level of ambition, states fail to prevent foreseeable human rights harm caused by climate change and would thereby need to be considered to violate their human rights obligations. Let me close with answering the question of whether climate change is a matter of human rights courts. And I think we all know by now it is. Absolutely. Because when states do not live up to their human rights obligations, this is a matter of law. It's not a matter of politics. But this does not mean that the court should be prescriptive in what each and every respondent states exactly has to do, the exact type of measures it has to adopt. This is in line with the court's decision in Codella versus Italy, where it underscored the potential importance of this approach. It said that the court notes that while it is not for it to determine precisely what measures should have been taken in the present case in order to reduce the level of pollution more effectively, it is undoubtedly for it to determine whether the national authorities approach the question with due diligence. Human rights courts and other courts, Supreme Courts and so forth, will therefore need to determine whether the measures taken by states were adopted with due diligence. This means whether they were reasonable and adequate to prevent risk from climate change for the enjoyment of human rights. Thank you very much.